Testing, testing.
It feels good to me. It feels good. I feel like we should leave it at this. If anything, drop it 1 degree lower, just because there's going to be a lot of people, so a lot of body heat. But I think it's fine. All right. Yeah. Thank you.
It's weird to have a weird wall. I'm always cold in this building because it fills up. It'll warm up when it gets full.
It will. All right, let's get this going here.
I mean, ages ago.
Yeah.
She's fabulous. And she hated.
Oh yeah, yeah. Yeah. Well, yeah, this memory stick and like the awful truth, story, theory, course.
Do you want to do it on? Do you want to do it on your computer?
Lots of stuff.
You want to do it on your computer or on here?
If you don't want to do it on
Yeah, no.
here, should we just pull out the stick?
Yeah.
Pull up program. Want a pitch up logo or a WCL logo?
I feel like pitch up would be good. All right, Jack. There we go.
I don't know if I have anything super high resolution.
Or whatever we can.
Yeah. Well, but maybe.
I love it.
Pretty good.
I like it.
Yeah. Yeah. Well, certainly you can break out. birthday in Poland. Bring in someone.
This was we had visitors.
This is woman who's working out and I met them there.
Oh, okay.
Yeah, but
Now I'll rest it.
how do you? Okay. Try me. Use the documentary.
A little bit.
Corey, last time I saw him at SCMS, he was getting out of space. I thought he was. No, no, I am.
Oh, you are? Is that what you are?
Part of
I will not leave.
Well, the world will be different, very different in 4 years. It's still, and it's still well, the real question is what but yeah, I don't think that's the longevity of the last. Because that's somebody in graduate school.
Photo in 1 minute.
Very, very conservative.
Have the police or
They're really short about more and more. But you know what?
You look at yourself not scratching your head as you're scratching yourself.
Theater.
Trumbo. I don't know. I got it. I mean, you know, obviously they want to do some sort of. And since the family's so large, see what we, so all writers are all systemic. But
No, you're right. Sketch all the.
And I also, they condense everybody to hold it again. But it definitely, so that was years ago.
Letter to
Yeah. Well, he was the only nasty thing to say.
Para atrás.
So that's
De ese lado. Hi, how are you?
yeah. Well, I saw James Lardner's name out there.
Mala no tiene corazón.
Yeah. I haven't seen it. Very young.
¿Vamos por un café, bro? Sí. Vamos a poner.
Are you
things haven't changed.
Unbelievable.
I woke up the one. Oh,
Just first of all,
Well, we've already done it. Yeah, we're talking about.
I didn't know this was.
Who's a programmer?
or the chief was the dean.
No, it was on NASAS. Up square. Yes. Yeah. I think they.
That was the key to us being alive. Jennifer has a summer of work. But she, theory of, right? She never really, she just says, they were so good. They were like, and so Jennifer's dad likes yeah, let's see what she has.
Might.
He found himself one day.
I found myself there too. So what's your? Not only is he saving, not only is he saving the first place,
Accreditation goes to them. If they get.
you can tell how we interact with the
But something that they can do without showing.
There's no sign indicating there's nothing in
so say there's a 95%.
I mean, it's sort of easy.
This is a sad fact.
Although I do
With
find
our eyes begin to open.
there was a third, like 5%.
You get, like,
Well, lots of friends. Sarah is. We were just
tanto. But the real world truth is that more and more students fail. And they're shocked. And they don't know what to do.
I'm just gonna sit right up here.
Good evening.
Yeah, I've got a duck out of the
Hi. Hi.
So you have to be on phone.
Excuse me. Yeah, sit up front.
Oh, good. Everything's fine. I don't know about this. Yeah.
Let me look here. I think I can manage that without too much of a mess. Yeah, I'll be okay. Well, now that. That would make sense if it would work. I think I like that. Yeah. Yeah, that's good. It's almost like designed for it. Oh, now I've got my slides up already. I didn't mean to do that. Okay. Or maybe, wait a second. Does it go to the side? Maybe. That's even better. Yeah, excellent.
Hey, how are you?
Feedback.
Excuse me. Should I do it now? Want to? Actually, yeah. Good evening, everyone. We're about to start. Good evening. I'm Michael Carroll. I'm the director of the program on information justice and intellectual property here at American University Washington College of Law. On behalf of our dean, Camille Nelson, who was unable to join us, I welcome you, and she's delighted to have this event to honor our colleague, Peter Jaszi. Just a couple of housekeeping matters. The bathrooms are over right here next to the elevator bank, and there's another set, one flight up and one flight up. If you could all take a minute and check your cell phones now and set them to stun. We're delighted to be here and welcome you to our new facility here on the Tenley Circle campus and in Claudio Grossman Hall. And we are joined here by Claudio Grossman himself, our recently retired dean after long service to the law school. On behalf of our program, we are delighted that we had the opportunity to name this lecture series after Peter while he was still in active service with us, but the opportunity rose and we seized it. So it is not often that you ask someone to deliver an eponymous, distinguished lecture, but Peter's not conventional. So of course we're not going to do things in a conventional manner. And who would you rather hear a lecture from than Professor Peter Jaszi, the accomplished storyteller, the man who's thought more deeply about copyright law than I think anyone else I know, and there are many very distinguished scholars who are in this room with us. For those of you who don't know, we're having a full-day conference tomorrow with authors who are contributing to an edited volume in Peter's honor. It's a public event. You're welcome to join us. And just, we're going to be copyright nerds to the end, because that's what we do. I would like to invite up now my colleague Christine Farley to introduce our distinguished lecturer. And so, Christine.
I actually brought notes, and I'm glad I did because I've seen so many faces that have made me even more emotional that I'm glad I have something prepared. Poor Peter. Poor Peter. Because Peter was reluctant when we wanted to change the name of our annual Distinguished IP lecture to his name, but we prevailed. And he was dubious when we wanted him to deliver the lecture this year. And so now poor Peter has to sit there and listen to me talk about him to people he knows. And he will smile pleasantly as I do so. But I'm delighted to have this task. So this task is a little bit curious because my job is to introduce to you somebody that you came to hear because you know. And how to do that properly. I've been thinking about this, and I thought in order to be informative for the entire audience, I would need to disclose some details about Peter's life that none of you knew. And that would be the only way I would be truly effective at actually introducing him. And Peter smiles pleasantly. But I decided not to do that. I was thinking, it caused me to think about Peter's career and how Peter is not the person who trumpets his accomplishments in any way. And so there are, in fact, a number of outstanding accomplishments that I'm sure none of you are aware of. All of you are aware of some of his accomplishments, but it's not because he told you about them, but it's because he involved you in them. And so I think all of you are here because you've been involved in some of the projects he's been working on over his long career. But he's had many. And so I thought what I would do is try to organize some of the things that he's done, and maybe you will learn a few things about what he's done. So first I want to talk about Peter as a teacher. Most of you are here, many of you are here, because he involved you in that project, whether you're colleagues or current students or former students, and I'm happy to see so many former students. As you know, Peter has taught here for over 40 years. I think 96 years, to be precise. And he has taught domestic and international copyright law. He's taught law and humanities courses, including law and literature, and a number of very interesting law and film courses. But did you know that Peter has taught in the first year? Did you know that Peter has taught every single course there is in the first year? So the breadth of his teaching is remarkable. Many of you know that he has been teaching in the IP clinic for the latter part of his teaching career. But did you know that the reason we have a clinic was because Peter brought in a grant of several $1 million in order that we could be one of the first law schools in the country to have an IP clinic. He was also the founder, it's kind of funny, he was the founder of our program, KIJIP. I say it's funny because at some point when I came here, and first it was just Peter doing IP, he said to me, should we have a program? And I thought, well, we already have a program, Peter. We have you. We've always had you. We've always had a program. And I think most people outside have always known that we've had a program because Peter's been here. Peter as a scholar. Many of you are very familiar with Peter's scholarship. But the first known writing that he's done that I've read, and you can find online, is for the Harvard Crimson, circa 1967-68, when he was 20 years old. And I actually encourage you to go read that. That's remarkable writing, amazing writing. I found in looking at that at some point when I was writing about photography that as an undergraduate, he had written about spirit photography, this thing that I thought I alone had found in the world, but quite remarkable writing. He's the author, of course, of a casebook on copyright, which is in its 10th edition, one of the leading casebooks in the country, the co-author of that book. Let's think about the different chapters of his scholarship. Of course, there is his work on authorship, for which he is renowned. And he has written several articles and book chapters on authorship and has edited a very well-known book on authorship in copyright, and I think he'll talk about that tonight. I hope he does. But did you know that he argued before 3 justices of the Supreme Court, Blackmun, Brennan, and Stevens, and before 1,000 audience members about the authorship of Shakespeare's works? So he's really brought authorship to everybody's attention for sure. Another area of his scholarship involves traditional cultural expressions, another area that he was one of the first people to write about and has been writing about since. Did you know that he took multiple trips to Indonesia where he led an interdisciplinary team of researchers to think about the traditional arts in Indonesia and the role that intellectual property would play in the protection and promotion of those arts? This work led to a book he published in 2009 called Traditional Culture, A Step Forward for Protection in Indonesia. And of course, the work that he's been doing very consistently for decades now is on fair use. And of course, he's been working very closely with Pat Aufderheide, who I'm sure, oh no, is she out of the country? Oh, she's there, Pat. Pat Aufderheide on projects around best practices in fair use, which has not just resulted in the publication of a book, but has resulted in many publications of many kinds of materials, including DVDs, which reach many audiences. And the book I'm mentioning is Reclaiming Fair Use, 2012. And many of you know Peter as a public intellectual. This is kind of a big category that I tried to lump a lot of things into. In 1995, Peter was the founder of the Digital Future Coalition, an organization of library associations and other public interest groups engaging in copyright advocacy during the momentous late 1990s. He has testified numerous times on behalf of copyright legislation. Copyright legislation is almost accurate too. And I just want to read to you a quote from Congressman Rick Boucher, who was a Democrat from Virginia, who was a congressman from Virginia. Peter wrote, "Through his testimony before Congress, Peter Jaszi has helped my colleagues better appreciate the importance of fair use to consumers, libraries, and universities, technology companies, and society as a whole. He has been a real inspiration to those of us fighting to restore balance to our copyright laws. With the intellectual support he has provided us, we ultimately will prevail." Peter has also played important roles in the Copyright Society of the United States, including as a trustee and as a member of the editorial board of its journal. He was, in 1994, a member of the Librarian of Congress's Advisory Commission on Copyright Registration and Deposit. In 2009, he was the recipient of the Champion of Intellectual Property Award from the District of Columbia Bar Association, which is given to a person who has served the intellectual property community with distinction, whose efforts have had an impact on intellectual property policy, who has encouraged innovation and the protection of intellectual property rights, and who continues to inspire and advocate for the intellectual property community. He was also the recipient in 2006 of the L. Ray Patterson Copyright Award presented by the American Library Association, and that award recognizes contributions of an individual or group that pursues and supports the constitutional purpose of the U.S. copyright law, fair use in the public domain. In 2011, he won the IP3 Award from Public Knowledge, and he has won numerous awards, but I know you want to hear from him and not from me. So how do you measure a career, an academic career? These days in academia, we're talking a lot, unfortunately, about measurable impacts. What measurable impact have you had? How do we count what you've done? Is it the number of publications, the number of pages? Is it the rank of the journal? Is it the number of citations? Is it the number of awards? Clearly, Peter has all of this going in his favor, but none of you are here because of any of those measures. This is a much better measure of a career. And I would submit that the measure of a career is the impact that you have. And I think everything I've read to you tonight is testimony to the great impact that Peter has had. And just to give you one little personal anecdote, sometime between 1991 and 1995, I read this line in a Duke Law Journal. The full-blown romantic conception of authorship has a continuing grip on the legal imagination. And I was probably a law student at the time. And that captivated me. I was so captivated by that that I pursued this area of law, that I pursued this career. And it's quite amazing to me, having been inspired by Peter's scholarship, that I've had this opportunity to work closely with him for all these years. Peter has been an inspiration to me and to you and to many others as a scholar, as an activist. The level of depth and insight and concern that he brings to all that he does is unparalleled. All of us and so many more owe him a debt of gratitude for what he has accomplished on behalf of the public in creating a balanced copyright system. So without further ado, it is my deep honor and pleasure to introduce Peter Jaszi.
My. Thank you, Christine. And thank you, Mike. And thank you all for coming out on this occasion. I am tempted, I won't do it because I've labored long and hard over these remarks, but I'm almost tempted just to throw away these remarks and just talk to all of the memories that are represented in this room by so many dear faces and the thoughts of so many valuable and inspiring collaborations that those faces bring back to me. As I say, I'm going to restrain myself because I have things I want to try to say, but the temptation is very, very, very strong. You are all individually and collectively dear to me, and the fact that you came to be with me and with us this evening is enormously meaningful. Christine, your remarks were very generous. I wasn't sure we had a program until the day you arrived. And then I knew for sure that we were going someplace. And in fact, we have. And we can boast now having a very real, and I'm happy to say, continuing institutional commitment to this field, and not just to this field, but to a particular angle, a particular approach, a particular vision of intellectual property studies, which, if not unique, is at least quite special in the larger context of legal academia. And I want to assure everyone that although with some reluctance I'm giving up the classroom, and with a lot less reluctance I'm giving up the committee room, I am intending to haunt these halls, and in particular to haunt the offices of PIDGIP until you'll have me, and perhaps a little longer than that. To everyone here, big thanks for going on this journey with me over all these many years and on making me feel part of a true intellectual community. One of the nice things about getting old is you get to tell your old jokes over again. And at the very first of these Jaszi lectures, I said something which I will now reprise, which is that I'm actually not the first member of my family to have a lecture series named after him. There is a lecture series, albeit a somewhat, I'm happy to say, more modest one, at Oberlin College that is named for my grandfather, Oscar Jaszi. They only have a lecture every other year. And also I can claim precedence over him because he didn't get his lectures until he was dead. And here I am. And when this happened 5 years ago, once I got over my initial reluctance, I thought, what could be better? I didn't realize that there was a possible sting in the tail of this generous offer. But here it is. I actually have to give the lecture, which didn't occur to me the first time. And I might have dragged my feet even more had I done so. Nevertheless, it's a pleasure. It's an opportunity. And it's especially nice to be able to talk to you tonight on the eve of tomorrow's conference because, and I hope many of you who aren't among the wonderful speakers who traveled from far and near to be on the program will actually also be able to drop in for all or some of the proceedings. They'll be webcast if you can't, but it's nothing like being there in person. It's really going to be a feast. We have the cream of several generations of copyright scholars here to talk about a very wide range of fascinating topics. We even have a few people whose expertise goes a little beyond copyright scholarship to keep matters interesting. And I won't, therefore, this evening try to acknowledge all of you who are going to be on the program tomorrow. That would take a large part of the limited time that I have. I will, however, though, pause for a moment to make some other acknowledgments to people of the generations who came before us, to our teachers, including my teachers, Benjamin Kaplan, and another person I count as my teacher, Ray Patterson, and also mentors. In my case, I would remember tonight Alan Latman and Edward Sargoy, who between them had a lot to do with helping me to become a good, or at least a better, academic and lawyer. But I promised that I would talk a little more about authorship tonight, and that's what I'm going to try to do, and I hope that it will be interesting. I've been pushing these ideas as I've prepared, and they may be not completely cooked, so I'll be interested very much in your responses. I've even I like the timing. I've even, against the habits of a lifetime, created a PowerPoint. Something which I almost never do, but because of the way this talk is structured, I thought it would be of some value. It's a very, very plain PowerPoint. And there's a title. So I want to start with a quotation. I want to quote the new Librarian of Congress, Dr. Carla Hayden, who told a Senate committee in the course of her confirmation hearings that she was going to make sure, as part of her oversight of the Librarian General and the Copyright Office in particular, that the office, and now I quote, functions in a way that will protect the people it serves, and that is the creators of content. That's an invocation. I take that as an invocation of the sort of the familiar and in some ways commonplace proposition that copyright exists by, for, and of, and certainly to the benefit of so-called authors. And that is, of course, an idea that I've engaged with on and off in different ways throughout my career. And it's been a complex engagement, and I want tonight to try to reflect some of that complexity by offering you a series of propositions, really, that have developed out of my thinking about the authorship issue. This metaphor of authorship, this idea that the interests of authors are at the very heart of copyright protection, is a very familiar discourse. It's also a discourse that can sometimes overwhelm more nuanced discussions of copyright policy and discourse. And I think it has the power that it enjoys, the power, as they used to say on the Shadow, the power to fog men's minds, because it has this remarkable pedigree. The idea of authorship that we have in copyright is not simply a construct of copyright law. The metaphor of authorship, which operates in so much copyright discourse and has the potential to both clarify and distort our thinking, is in a sense a borrowing on the part of law from other older and in some ways perhaps even more powerful discourses. The idea of the author as it operates, it has operated, the romantic author, as Christine so graciously said in her earlier remarks, the idea of the romantic author as it has operated to clarify and distort our thinking about copyright is the idea of the special inspired person who concentrates in himself or herself, on the one hand, a kind of special entitlement, which is, of course, the reflex of the great gifts that he or she, as a kind of lay prophet, can impart to the public at large, and on the other hand, also demonstrates a sort of heightened vulnerability. These special people who walk among us, the authors, the inspired few, the geniuses of cultural production, also turn out in the usual way in which we describe and think about them to be really, really poor business people. They're easily led astray. They don't bother about money. They're in a sense too elevated, too busy, too distracted by the demands of art itself to look after themselves, and in particular, of course, to look after their poor families, who are likely to be left destitute when they pass from the scene. And this is a really, really strong trope. Big inspiration, big entitlement, high degree of specialness on the one hand, and intense vulnerability on the other. It's the recipe, really, for some kind of protective legal intervention. How could you not want to devise laws that would help out this kind of special group of people? The problem, as those of us who actually get involved in the work know, is that often the real circumstances that we encounter as lawyers don't measure up to this sort of archetypal vision of the romantic author genius. Occasionally they do. I once had the privilege, and it really was a privilege, to be for a while a fly on the wall in the capacity of an expert witness in an epic litigation battle pitting the estate of Igor Stravinsky on the one hand against the Walt Disney Company on the other. And not just the Walt Disney Company, but the Walt Disney Company as represented by the motion picture Fantasia, which was, of course, a great personal project of the man himself. So we had the ghost of Disney, in effect, in a courtroom in Judge Duffy's courtroom in the Southern District of New York, fighting it out with the ghost of Igor Stravinsky. It was pretty impressive stuff, and you got a touch there, a feeling about what it might be like really to be in the presence of author geniuses. But it's not so common. A more typical experience is one I had a few years later, a more, you might say, literally disillusioning experience when I got to be an expert witness in a dispute pitting the Internal Revenue Service on the one hand against the estate of Victoria Andrews, who, as many of you I'm sure know, was the founder, creator of the children in jeopardy literary genre, best exemplified by, of course, her first novel, Flowers in the Attic. This is an amazing story, which I am happy to tell at length, as some of you have heard me tell at length. And you know, it takes about an hour and a half. It does have a good punchline, I have to say, maybe afterwards. But suffice it to say that, you know, this was much closer to the reality of the authorship business. Ms. Andrews had passed away, having founded this extremely popular literary genre. She'd left no manuscripts behind. The representatives of her estate decided that they would surreptitiously hire a ghostwriter to carry on the tradition, and did so to great success, at which point the IRS tried to hit them up for a lot of money. And there was a wonderful tax case. You can read about it in the federal reports if you want. But this is authorship as she has lived, you might say, rather than the romantic vision that I was, of course, brought up to admire and to some extent even believe in. I want to come in a moment to that question of early belief, because it is an important part of the story that I have to tell about my engagement with this topic. First, though, I want to make an acknowledgement, which is, I think, something already many of you know, and that is that through most of my career, certainly the second half of it, I have lacked either the intelligence or the integrity, or perhaps both, to draw a clear line between academic pursuits on the one hand and activism on the other. At a certain point, I couldn't do it anymore, and so I stopped trying. And one consequence of that act of giving up, of abandonment, was that I'm bound now to measure the value of my work so far, whatever it may have been, at least to some extent in terms of impact, not the sort of academic impact to which Christine was referring earlier, but, you know, impact in the world, because I've spent a good deal of time in the last 20 or 25 years trying, at least, to have that kind of impact. Well, it hasn't been all that much of a success. I think that it's likely that when I'm finally planted, my tombstone, or at least my copyright tombstone, maybe the copyright side of my tombstone, will say, could have been worse. And I suppose, in a way, you have to settle for what you get. But it is true that at every moment when I have felt that the work has been useful in some way, has been contributing in some way to better understanding or to progress in thinking about copyright policy questions, or to the clarification of the thinking of others. I was really deeply touched by the quote from Rick Boucher that you read, Christine. It means a lot to me, and I like to think that in a very small part it might have been true. Throughout all of that, this business of this engagement with the idea of authorship, trying to think it through, trying to think through the role that this idea has played in copyright law, trying to think through how I feel about the idea, how I respond to it. This has been a kind of bright connecting thread between all of my projects. It has been probably the one thing that connects that kind of disparate confusion of initiatives to which Christine referred initially. And I'm going to try tonight, among other things, to draw a little bit of that through line for you if I can. I also need to say that this bright thread, as it has unwound over the years, has also gotten more and more entangled with another, and that is, of course, the idea of a public interest in intellectual property law, which I think everybody in this room takes as a given, but which I can tell you was not a common term in intellectual property discourse 50 years ago when I got started with this stuff. I think I managed to get through a wonderful law school copyright class with Ben Kaplan, for example, without ever hearing the phrase public interest spoken, which doesn't mean that he didn't appreciate the value. It simply meant that there wasn't yet a vocabulary for it. And there is now. And as that vocabulary has developed, it has gotten sort of mixed up in my own mind, intertwined, not necessarily in a good way, but in a rich way, not necessarily in a clear way, but in a rich way with my thinking about authorship. So again, what I've got here are 7 propositions, loosely linked, about authorship that I want to offer to you as a sort of partial summing up. And this is where the PowerPoint is fun, because the PowerPoint is animated. Look at that. I didn't do that myself, I have to tell. I thought I could, but late last night I became desperate and I called up for help. So the first proposition is that this idea of authorship, this rhetoric of authorship, this trope, this metaphor, is really tenaciously persistent and remarkably ubiquitous, even in our times. And it's odd in a way that we, or at least that I, should be talking in the early 21st century about the shortcomings of a concept that really enjoyed its first and greatest flowering in the latter part of the 18th and perhaps the first third of the 19th centuries. There's something odd going on here, that this idea which flourished, especially in literary culture at that time, sort of hangs on so doggedly in the discourse of copyright itself. I think that's because, and here, forgive, I don't know that this metaphor works. I struggled with it, not entirely satisfied, but I put too much effort into it to want to discard it entirely now. I think it's because this idea of romantic authorship was flourishing in the petri dish of literary culture at about the same time that in an adjacent receptacle, the models for what would become Western-style copyright authors' rights, call it what you will, were also taking form. And at some point, there was an exchange of conceptual DNA. At some point, this idea about the celebration of the author genius that was so profound and prominent in literary culture sort of jumped over into the copyright dish and took hold there. And even though it's more or less dead as far as literary culture is concerned, it lives on in copyright. It's like a sort of virus that is extinct, in its original environment, but has taken hold in a new host. And it has hung on with a remarkable degree of tenacity. I should also say that I came to this topic long before I was a law student, let alone a student of law, in an innocent, honest, and sincere way, and not intending any harm to the idea of authorship. Indeed, when the idea of authorship first appeared in my life, it came as a kind of almost a salvation, because back in those days, undergraduate days, I was very much involved in the student film society scene at in Cambridge, at Harvard, and MIT. It was a nice setting to be a student involved in film society programming, because on the one hand, there were lots and lots of potential viewers in this sort of large set of overlapping academic communities. And on the other hand, there was no formal film studies program of any kind in any of the universities. And so, we could do whatever we wanted to. We had absolute free rein. We could make it up as we went along. And we had an enormous amount of fun. I said that I wasn't going to acknowledge people from the program tomorrow, but I do have to acknowledge one person, because he has come tonight, and he is, I think, the oldest, not the oldest, let's say the academic colleague of longest standing who is here tonight, and that's John Belton, who was a co-conspirator of mine back in those days in film study days, and we taught together in what was actually, as it turned out, the very first film studies course that Harvard deigned to offer. And we learned a lot from each other and from the cohort of people we were working with. But we had a lot to make sense of. We without any sort of adult supervision, we were trying to make sense of, let's say 100 years worth, give or take, maybe 85 years worth of American cinema. And there was no guidebook, there was no roadmap, there was no way of understanding all of this diversity until we were given the gift of Andrew Sarris's book, American Cinema, which was published in 1968, but which had sort of circulated in Samizdat versions for a couple of years before. And Sarris, in his inimitable, brisk and efficient way, had sort of compressed and organized and rationalized the insights of a generation of French film scholars, the Cahiers du Cinéma critics who had created the original Politique des Auteurs, and made it accessible to people curious about film everywhere, and in particular, people curious about American film in America. And so this book, it is fair to say, was a kind of Bible. And it was, at least to me, and it was organized very clearly along the lines of we look back now, and I even say naively so, but organized very much along the lines of simple faith in the proposition that remarkable individual genius authors can be charged with responsibility for bodies of work that are impressed throughout with their personalities, values, and tastes. It was a way of making sense out of the history of American film, and I, at least, and I think others too, gravitated toward it immediately and strongly. I was never without that book. And at that time, I took all of this with the greatest seriousness. It seemed like an idea, this idea of inspired authorship, as instantiated there in the context of cinema history, that made the greatest possible sense because of its explanatory power. And it followed me on my journey. It followed me on my journey from film society programmer to cadet film teacher to theater manager and programmer, which is a role I played while at the same time trying to go to law school. And then, for the same reasons, into the study and eventually the practice of copyright law. And I actually think that I may be one of the only, perhaps the only, or at least a member of the only legal team ever to litigate a case based strictly, as far as our case theory was concerned, on the principles of Androcera's American Cinema. And this is a case called Epic Against Killiam Shows, which I was very, very lucky to be involved in as a young lawyer. And it really was the auteur theory in court. We had, well, our client had been accused of infringing rights in an old movie, the D.W. Griffith movie, the now infamous, although it wasn't quite as toxic then as it is perhaps now, Birth of a Nation, 1915. And our client had really only one viable defense, and that is that the renewal in this case, the copyright renewal claim in The Birth of a Nation had not been validly filed. There was a copyright renewal claim, but it was in somebody else's name. And in order to demonstrate that there were no rights in the film, and thus no rights that our client could have infringed, we had to show that Griffith was the author of the film, and therefore the only person entitled to renew. Griffith not having renewed, the film then would have entered the public domain, and our client would have been in the clear. And so our job was literally to take the premises of cinematic auteur theory and translate them into legal case theory, because the basic principle, as most of you know, of the work for hire doctrine, especially the work for hire doctrine as it stood under the 1909 law, was that the film sort of, the work sort of belonged to whoever was really in control. So if Griffith was really in control of the making of The Birth of a Nation from day to day on the set, then it followed that nobody else was the author, and therefore nobody else was entitled to renew. And so we had the pleasure, and it really was a pleasure, of digging deeply into the records and archives of the making of The Birth of a Nation in order to establish through forensic proof the fact of Griffith's personal dominance over the production. And it was really a kind of an amazing, amazing experience, one that one could not have now, in part because so many of the people who were alive at that time are no longer with us. It was in the course of preparing that case that I had the opportunity to sit at a lunch table at the Beverly Hills Hotel and spend 2 hours talking to Miss Lillian Gish about her experiences with the man who she would only refer to as Mr. Griffith. And it, remarkable. We put on the stand Joseph Henneberry, an old actor. I was going to say ancient, but old is nicer, and I'm sensitive to these things now. An old actor who had played the role of Abraham Lincoln in The Birth of a Nation, and who loved to talk about Griffith's genius and the way that he dominated the production. And we won. And it was very gratifying, and it was, as far as I can tell, as I say, the only time that the auteur theory has gone to court and has proved triumphant and has managed to get somebody off the hook in an infringement litigation. So I didn't have any doubts. I was in. I was convinced. I thought this was an intellectually valid and powerful way of thinking about the creative process that, as far as my extremely limited experience was concerned, interfaced, merged well with copyright law. And I thought, well, one should be able to ride this authorship stuff quite a long way. This is powerful. And then I had another litigation experience, which sort of knocked me back a little bit. And I think as I go back in retrospect, probably was the source of the beginning. This was the moment when my doubts began about the validity and the explanatory power of this authorship construct. It was another case called Rohauer against Killiam Shows a couple of years later. And the issue in that case, as I'm sure you all remember, was the legal relationship between a derivative work and its underlying source following the renewal of copyright in the source work. And the view we took, and the view that initially prevailed, although it was subsequently tossed aside, roughly, rudely tossed aside by the U.S. Supreme Court in Stewart against Abend, was that one work was as good as the other, that the derivative motion picture had as much right to exist and flourish in copyright space as did the underlying novel, that they should be considered autonomous, independent works enjoying autonomous and independent legal lives. Well, not so the argument on the other side, and not so eventually the Supreme Court either. Instead, eventually, we were taught that the derivative work was a kind of a secondary contribution, and that it was subservient to and legally subject to the higher claims, the better claims of the author of the original work. So I began to see that in this idea of authorship, this concept of authorship, there also sort of adhered an idea of hierarchy, an idea that early comers had better claims than late comers, or that creators who worked somehow closer to source material had better claims than those who worked primarily on secondary cultural materials. And this became worrying to me because it didn't seem right. It didn't seem correct. It didn't seem, of course, didn't represent the interests of my client in that case. But more to the point, it didn't seem to me to make a whole lot of sense. And it also didn't make very good policy sense, I thought. I thought, a rule like that follows the logic of romantic authorship to the extent of giving the first comer in some area of creative enterprise a permanent veto over the subsequent contributions of others. That's not only odd law, but it's bad policy in the sense that it's likely to have the effect of causing interesting, useful material to be withheld from public availability rather than made broadly open to the public. So I wrote some about that, and as I wrote about it in I guess what was actually in effect my tenure article, my feeling that there were problems, that there were difficulties with transferring the cultural trope of romantic authorship into the domain of law became more and more acute. And eventually I sort of stopped and said, somebody else must have been thinking about this. And I went and did a little research, and the first thing I found is that there were indeed people in literary studies. My dear friend and longtime collaborator Martha Woodmansee was one. Mark Rose was another. People who were already exploring the implications of the ideas of Barthes and Foucault, the skepticism that they had brought to literary studies around the idea of authorship, who were already applying those ideas, those skeptical perspectives to the history of intellectual property in Germany and the UK. And then, of course, I followed another track. This was a lot of fun. This was probably the most fruitful, most enjoyable single episode in my entire scholarly career. I followed another line which led me to start reading about reader response theories and the way in which reader response criticism has had the effect of kind of destabilizing the sovereignty of the author in cultural studies. And then just when I thought that I was really onto something new, I picked up the little volume that includes the Carpenter lectures that Ben Kaplan gave at Columbia Law School in 1966, and discovered, of course, that, prescient as always, he had been there before us and had more or less laid out this critique in a footnote or two a decade or 2 decades before anyone else arrived at it. That was humbling, but then again, I've become accustomed over my career to being humbled in that way. I have never had a useful idea about copyright which it turned out was not in some way prefigured in something that Ben Kaplan wrote. It's just the way it is, and you have to learn to live with it. Anyway, by and large, despite the somewhat deflating discovery that, as usual, my teacher had been there before me, I was still kind of inspired by all of this. And then I became more inspired still because I discovered very quickly a community of other contemporary scholars, legal scholars, of whom my friend Jamie Boyle, who's come to be with us tonight, is one. And of course, without Jamie, it would never have been possible, among other things, to argue about the authorship of Shakespeare. We made a community very quickly, and there was lots to talk about. This became not a personal idea, but a shared idea for all of us. And I think the next years, the years in which writing that incorporated various versions of what I sometimes refer to as the critique of authorship was written and published, were very fruitful, satisfying, downright, for me, exciting ones, except I still didn't know whether it mattered. I still didn't know whether it was consequential. As I mentioned, I'd had some glimmerings of the possibility that what you believed about the place of authorship and copyright might have consequences, but they were glimmerings only. And then I began to have some other insights. This is after Noam Chomsky, and the long form, I think, is that when politicians and policy experts in the copyright area start talking about authorship, you really should begin, if not, maybe counting your fingers would be more like it, because there is an element of flim-flam here that is sometimes very, very pronounced. There is a very sincere, a very important, a very profound way in which copyright discourse has been informed by the authorship construct, but there's also a sense in which sometimes the authorship trope has been manipulated as a kind of smoke screen. Here's my favorite example. I'm not going to talk about anything new tonight except this. And this isn't new in the sense that what I'm going to disclose is old history, but it's not history that I, or as far as I know, anyone else has ever written up. And I'm not sure many of you have heard it before. You may or may not find it exciting, but here it goes. Back in 1998, when we were debating the never sufficiently to be studied Sonny Bono Copyright Term Extension Act, the proponents of that law claimed that its objectives were somehow inscribed in international law in ways that really gave us, in the United States, very little practical choice, except to tack 20 years on to almost every copyright term that was going at the time. Mary Beth Peters made claims of that kind with great sincerity, I think, in congressional testimony, and no less a distinguished entity than the Solicitor General's office filed a brief when the issue finally came before the Supreme Court, stating that The 1908 revision of the Berne Convention, which provided for the first time the life plus 50 term of protection, was, and I quote, designed to provide compensation during authors' lives and during the lives of any children or grandchildren. The 3-generation argument. And that, of course, meant that because life expectancy had increased, it was time to add 20 years to go from life plus 50 to life plus 70. Now, putting to one side the fact that actuarially that proposition is nonsense, and going instead simply to the historical part, I was puzzled by that at the time. And I did a little digging, and I found a few things, and I didn't do anything with them. I put them in a file, but I dusted them off recently. Viewed from a sort of unreconstructed auteurist perspective, this argument, in 1908, the framers of the Berne Convention wanted to provide for 3 lives in order to make sure that these feckless authors who were such notoriously poor businessmen would leave behind a legacy that their children might subsequently and their grandchildren might subsequently be able to exploit. That all made perfect sense. A copyright system that is author-centered could be expected to elevate considerations relating to the welfare of creators, survivors over other, arguably more relevant ones like, oh, I don't know, say the public domain. But there's a problem, as it turns out, and that is that there is no such language in the travaux of the 1908 revision of the Berne Convention. The Berne Convention doesn't, the 1908 text and subsequent Berne Convention text do not talk about the principle of 3 generations. It is a fiction. It is a figment. And the question then, of course, becomes, well, where does it come from? How did it become such a matter of copyright gospel that the Solicitor General of the United States felt comfortable about including it in a brief to the United States Supreme Court? And it turns out that the responsibility lies with a gentleman, French copyright theorist and bureaucrat named Claude Massuet, who asserted this proposition in a document of which he was the author, the WIPO guide to the Berne Convention, which was prepared in connection with the promulgation of the 1971 Act of Berne. It is in the guide for the first time that you find the assertion that the life plus 50 term was designed to provide for the life of the author and 2 subsequent generations. Now, the guide is entirely non-authoritative. There's no doubt about that. It's a personal interpretive document that was for a while, but I think is actually no longer distributed by WIPO. And nevertheless, as you can imagine, its inclusion in this apparently official document really caught the general imagination. So then I began to think, well, how can Claude Massuet have thought that? And I began to trace back the pedigree of Massuet's views, and it turns out that the support for the proposition stated in the guide is to be found, surprise, surprise, in the previous writings of Claude Massuet. It is a proposition without any visible means of support. It hangs out there in the air, but because of its plausibility, because it fits, because it connects to our general naive belief in the idea of authorial entitlement and authorial vulnerability, it went over. And everybody was convinced. And at the time, nobody thought to question. I thought, well, when term extension comes along this time, I'll drag this out and make something out of it. But of course, it looks like it may not be coming along this time. And in that case, I have nothing to do with this tidbit except to share it with you tonight as an example of how the effect of author thinking can warp discourse, which leads me to another proposition. And that is that we all contribute to some extent to the grip that author talk continues to hold on copyright discourse. Certainly maximalists do, but so do us minimalists, us copyright skeptics. Because we tend, when we are driven to provide an argument that is based on fundamental premises rather than passing policy preferences, to go back to constitutionalism. And we tend to say, well, you know, if you really parse Article 1, Section 8, Clause 8, it turns out that the only thing that copyright was supposed to do wasn't supposed to reward authors, it was supposed to encourage authors. It was supposed to stimulate authorial activity, and of course, therefore, overprotection, protection that is unnecessary or ineffective or even inefficient to accomplish that goal of stimulation is inappropriate protection. The problem is, I think, that without meaning to, by relying on that argument, which is our sort of ultimate fallback, our crutch, the corner we retreat to when we have no place else to go in making our arguments for less rather than more protection, we implicitly validate the authorship construct, this idea that something about what authors do, something about what a special class of people who aren't everyone, who are only someone, who are distinguishable in some way from the crowd, that something about what authors do is particularly important. And we can argue endlessly about the implications of that special importance, whether it is that these folks deserve a great deal of protection or only a little bit of encouragement. But one way or another, by making that argument, we in a sense concede the proposition. And yet, at the same time, as my heading indicates, we don't always take it quite as seriously as we might. So on the one hand, we are buying into it, minimalists and maximalists alike. We are serving this ideology, this belief system. And on the other hand, when you actually look at doctrine, if you look at, well, let's not even talk about moral rights. Let's say, for instance, doctrine having to do with issues like the unprotectability of author's style, which is, of course, a widely accepted, seldom challenged truism of copyright law. Or when you look at rules about how issues of collaboration are handled in copyright law, something that I've written about sometimes, you immediately see, and I won't belabor the details now, that there is a misfit. There is a lack of clear connection between the conclusions to which a sincere and thoroughgoing conviction about the importance of authorship would lead, on the one hand, and the conclusions to which we have, or at which we have actually arrived on the other. What's going on? Well, it's hardly a valuable new insight, but I'll offer it simply because it has been, I realize, quite important over years as a point of reference for me, is that what we've really got going on here, sort of roiling below the surface, is a kind of Manichaean conflict between two essentially different and essentially irreconcilable ideological visions of this field. The one which elevates the creative process and the unique individuals responsible for it, and the other which asserts the value, the paramount value of public access, openness, and all the other terms that we associate with that complex of ideas. This is a very, very fundamental and probably irresolvable conflict. We try to manage it rhetorically, but time and time again, when we get down to the level of doctrine, it turns out that the rhetoric doesn't really explain the compromises that the law reflects, as well as a recognition of this polar tension between opposed poles may do. So here's another proposition, if I can get this. Well, I've already talked about that, so I'm going to leave that alone and actually go on to a further one. Here I thought I was going to stick to my notes, and I'm actually doing things out of order. Think of that. How spontaneous of me. The next proposition that I want to offer you is that the fairness claim, and this is the hardest one for me to acknowledge, I have to say. It's the one that I find most disturbing and challenging from the standpoint of my work. And that is that the fairness claims of authors, real life authors, not metaphorical authors, not Wordsworth and Coleridge, but people who actually labor from day to day to make creative work to sell, that the fairness claims of authors are sometimes more real and more acute than it's comfortable for theorists to acknowledge. Christine mentioned earlier that I was lucky enough, and it really was a matter of great personal good fortune, to be involved in 1994 in the deliberations of the Library and of Congress's Commission on Copyright Registration and Deposit. It had as its acronym ACCORD, although it didn't quite correspond ever to the name of the commission, nor, I'm afraid, did it correspond entirely to the mood of the group, which was composed of industry types and academic types, more or less in equal numbers, and which deadlocked over the question of whether or not the provisions of Section 412, which, as you know, condition the availability of costs and attorneys' fees in copyright litigation where plaintiffs are concerned on timely copyright registration, should be removed from the act. It was then proposed in Congress. There was a very strong congressional push for the repeal of 412, and the Librarians Commission was supposed to render an expert opinion on whether that repeal was or was not desirable. In the end, as I've suggested, the commission deadlocked. There was no majority report, and I think, in fact, that the failure of the commission to heartily endorse this legislative proposal probably contributed in the end to its demise. When the commission reported as deadlocked, some of the air just went out of this initiative, and it never really got fully inflated again. So to this day, we have Section 412 to thank for the fact that we have enough incentives to registration in U.S. copyright law to provide the basis for a comprehensive, if not a complete, record of American creativity. And that was essentially the argument that I and others made in Accord, and that is that although eliminating Section 412 might in fact be a benefit to small authors who were taken by surprise by the fact that by virtue of having failed to do certain acts early in the history of their copyrighted works, they might subsequently be barred from collecting reasonable compensation for infringement in later years. Although that was certainly tugged at your heartstrings, the interests of the system, and in particular the interests of the bibliographic value of the registration database and the research value and the business value of the registration database, made it important for us to sort of, turn our face against the small authors, those who were the victims of these traps for the unwary. And I'm proud of that. I'm proud of having been a part of the process that probably helped to preserve Section 412 in its present form. But I also have some regret that it wasn't possible then, and hasn't been possible since, to accommodate the real interests of individual creators who are sometimes taken by surprise by this last remaining significant U.S. copyright formality. And I don't know that there's anything to be done about it, or even that there is anything that could or should be done about it, but I make the point because even though the critique of authorship has made it easy, comfortable, and respectable for me and others to take a kind of a hard line in some copyright policy situations, to reject this trend or tendency toward mystification in favor of a view of policy that gives more emphasis to the collective interests of the public at large. It has occurred at some cost, and those are real costs. Now we have before us another similar might be a stretch, but a related proposal. The Copyright Office has been active in developing, and the House Judiciary Committee seems at least hospitable to considering a proposal to create so-called copyright small claims courts, which would provide an expedited forum for the litigation of copyright infringement claims below some amount, and would accommodate, so the argument goes, the photographers and illustrators and other small creators who are, in effect, again, their claim not necessarily altogether true, who are blocked effectively from access to federal court litigation at the sort of full district court rate. And again, this is an attractive proposal from the standpoint of justice for small authors. And I once again find myself in the sort of churlish position of wondering whether or not the cost is going to be, the benefit is going to be worth the cost. The cost that concerns me, and this is something I would urge all of you to pay attention to if you're not already over months and years to come, is the possibility that expedited processing of this kind may in the end be inimical to the flourishing and continued growth of the idea of user rights, and in particular the idea of fair use in the copyright system. Remains to be seen, but it's another example, not unlike the situation as it stood back in 1994, where I feel myself a little bit caught between the desire to be accommodating to the real interests of small authors, real authors, day-to-day creators on the one hand, and my concern for policy consequences on the other. Oh, now I've gone too far. Well, that's all right. The next heading is the one that I come to now, which is that I think it's valuable when we can to try to make a distinction, and maybe some of these problems that follow the lines of the one that I've just described around in small claims court could be resolved. If we make the distinction, if possible, in a practical sense between authorship, this fraught concept, this mystified concept of authorship on the one hand, and cultural production on the other, that the latter is a more inclusive, a more descriptive, and at the end of the day, perhaps also a more useful category. One of the lessons of my wonderful 15 years of experience in clinical teaching has come from having had with my wonderful students, many of whom are here tonight, the opportunity to represent many small creators, to understand and try to help to solve their real world problems, which often don't have anything to do with copyright piracy or even intellectual property writ large, but instead have to do with securing various kinds of business advantages, getting better contracts, getting better deals with landlords. There are so many things that actually matter to small creators that I think we have to be extremely careful about fetishizing the intellectual property issues as though they were the heart of their concerns. In the work in Indonesia, to which Christine referred, and several members of that Indonesian team are, I'm happy to say, here with us tonight and will be speaking tomorrow. You know, we talk to a lot of people, a lot of practitioners of the old arts about their situation. We talk to artists and dancers and singers and textile artists and puppeteers and carvers, and we tried to ask them this was all sort of the whole length and breadth of Indonesia. Well, not Aceh and East Timor, but everything else, more or less. We tried to ask them what their lives were like, what their situations were, what concerned them, what made it possible for them, or in their view, threatened their ability to carry on the cultural practices that they had in turn inherited from generations before, that they had modified and varied and continued to practice fruitfully in their own times. And we heard about a lot of things. We heard about the problems that have arisen as a result of the failure of government to provide any form of subsidy for traditional cultural artistic activities, including performing spaces in local communities where it would be possible for community members actually to show off their arts to the rest of the community. We heard about problems with the education system, the failure to represent traditional music as distinct from Western music adequately in the schools. We heard about the fact that the younger generation, as usual, were too distracted, were too enamored of Western culture to be interested in doing the slow, difficult work of learning old dances or old songs. It was a list. You can go to the book that Christine referenced and see the list. And somewhere at the very, 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 very bottom of that list, a few people said, well, maybe we could benefit from some intellectual property, although we really don't know what that is, and we're not sure that it has any meaning for us. It was not at the top of the list. It was not the thing that these admirable, struggling custodians of great and important traditions had in mind. They had far more urgent things to think about than that. So these people, whether they're clinic clients or whether they're struggling Indonesian cultural practitioners, whether they are fan fiction writers or vidders or other voluntary participation in the remix culture, These are all really, really important factors, elements, contributors to overall cultural protection, but they don't really fit the classic vision of authorship, the 18th and early 19th century romanticized view of the author genius very well. And indeed, they don't recognize themselves in that conception. So perhaps it is time, I would argue, for us to focus more on the needs of systems of cultural production and less, perhaps, on the requirements of authorship as classically understood. There are many ways of talking about the goals of a copyright system. And it continues to be fascinating, even difficult to understand, why our collective vocabulary always seems to return to this one set of somewhat outworn tropes. Too often, as I've suggested, I think it's a way, this resort, this fallback on author talk is a way of avoiding what's really at stake rather than confronting it, a temporary crutch rather than a permanent support for sound policy making. And I do think that finding other discourses, better discourses, truer discourses is important. We need to think of other ways of characterizing and representing the interests of the whole range of participants in the system of cultural production. We have to think about the interests of consumers. We have to think about the interests of users. And one of the reasons that I'm so proud of the fair use work that, with Pat Aufderheidi's help, I've been able to do in the last decade is that it has been focused very much on the rights, the interests of users, with the recognition that all of those users are themselves makers, all participants in the overall system of cultural production, but not necessarily individuals who would recognize themselves or would even want to be recognized under the inherited rubric of authorship with a capital A. It may be that, as Foucault suggests, as we deconstruct authorship as such, we will never be able entirely to rid ourselves of the author function. By that we mean a system for assigning certain kinds of legal and cultural authority over particular texts. But I'm optimistic that we can go forward without that ideological baggage in other ways and in other directions. So now, having messed this up thoroughly, I want to come back to my final proposition. Well, I can't find it, so I'll simply tell it to you. And here it is. Authorship, this time with a small a, describing the real activity rather than the mystified version of it, is real. But it's widely distributed, more widely distributed than we might imagine. And it needs to be promoted with a recognition of that fact. Far from being the gift of the few, it's the fate of the many. Cultural participation, we know, is a human right. And human fulfillment depends, at least in part, on our ability to engage in culture making. I'd suggest that it's likely to do so even more in a future where meaningful work may become ever more scarce. And the question posed for us is whether or not we can grasp fully the options and alternatives offered to us all as culture makers by the new creative tools which technology provides and the new opportunities for cultural consumption that come along with it. I think the answer depends whether we will grasp that opportunity or not on on a couple of open questions. Will we be able to embrace the principle of openness as an essential characteristic of future information exchange regimes? If not, I fear we are doomed to lose the opportunity that I have just described. And will we be able to acknowledge the inevitability of creative collaboration between men and machines? And even perhaps, this is a talk for another time, between human beings and other species. The question, I think, depends very much on how we deal going forward with the authorship hangover, if I may characterize it in that way. But we have an opportunity, and if we take full advantage of the opportunities afforded to us, I think that we have a lot to look forward to. Our success is going to depend, as I say, on our ability to maintain and even deepen our skepticism about the natural claims of authorship. In decades to come, information justice may mean looking for and honoring all expressions of the creative impulse, not merely the most stereotypical or the most glamorous ones. Thank you. Thank you very much. Mike, have we got a few minutes? Oh, I'm sorry. Have I gone that long? I was not keeping track. I turned off my phone. That's always a mistake. Oh, yeah, it is long. It is late. I'm sorry. Forgive me. I see that I did go long. Well, we can always do that. And then there's tomorrow. All right. Why don't I let you guys go eat?
So here's the plan of action. You do get to eat. You do get to have a drink. We, instead of, I know there are many people who want to make a toast to Peter. There will be a champagne toast around 8:15, but we're not going to ask people to step forward and formally occupy the conversational space that way to maximize the flow. Outside in the hallway, you'll see a PowerPoint that's running with lots of toasts that have already been contributed. If you didn't get the notice or you want to contribute, there is a link on the event page for this with a jot form. Please make your toast to Peter. We'll keep that form open, and then we're going to present it to Peter as a book later on. So if you haven't had a chance to have your say, there still is an opportunity. And please get a drink, something to eat, and we'll have a very tiny, small program in the hall next door, and enjoy the conversation and give Peter another hand, please. All right, that was beautiful. Thank you. I'm gonna, sorry for the technical difficulties.
No, it was my fault entirely. It is true that one probably should have provision here for papers next to.
It should be like a slide out.
Yeah, a slide out or a pull out or something like that. But on the whole, it went well.
That was great. What a great turnout.
No.